You mentioned item that 3 and 4 loads. Let's say leaders is out of station, let's say
Sorry. We'll take up this matter. Simple issue. Whether authority is there or not. If there is no, sorry. We have adjourned too many times. No, not possible.
so these are only.
No, you have not notified also. Sorry. Yes, next case.
I beg to mention item number 7, my lord. So I'm seeking some accommodation, my lord, with the consent of the other side, my lord. Mr. Yes.
There is no consent because the urgency was expressed by
yes.
them on
Well,
the last date. Accordingly, the
I-
matter was listed today. Senior counsel is also leading in this case, my lord. So let it be listed in November, first week November.
Yes, ma'am.
Okay. On the prayer of the learned standing council of the FPDCL, matter stands adjourned and be listed in the first week of November.
Deeply agreed.
My pleasure, Sir Lordship. Lordship, I beg to mention for item number 18 and 19, the hearing matter. The matters have become infructuous, Lordship. I am appearing on behalf of Ms. A. Talukdar.
It is, you are appearing on behalf of?
A. Talukdar, Ms. A. Talukdar.
Okay, she is here.
Please no.
She is not available.
Thanks.
20.
18 and 19.
What about 20?
20, Lordship, we are not the counsel for a
Okay.
petition.
18 and 19, learned. It is submitted by the learned counsel for the petitioner that this writ petition has become the writ petition as well as the contempt petition has become infructuous. In view of such submission, the petitions stands closed, being infructuous.
Last order, Lordship.
In spite of this court's order dated 6/9/2024, the registry has not reflected name of MS R.S. Chaudhuri, learned counsel for the Assam State Legal Services Authority, in the cause list. Registry shall comply with this court's order dated 6/9/2024 and list this matter after vacation.
Admission item 1.
None appears for the petitioner on call. None did represented. None anybody represented. None did appear for the petitioners when the matter was called on 2/9/2024. Full stop. Yes, who others are there? So though the respondents are duly represented. Full stop. In view of the aforesaid, the matter stands dismissed for non-prosecutions. Interim order of status quo dated 22/03/2016 stands vacated.
Okay.
Not.
Also, my senior Mr. P. Naik is on his way. That will be taken up after something.
Five and 6.
Yes, Jorhat Municipal
My lord,
Board.
here,
Who is for Jorhat Municipal?
They have filed an affidavit that your lordship will find my lord. 9/11/21.
9/12.
9/11/21. Filed by respondent.
9/11/21. Pursuant to this court's earlier order.
Page 7, my lord. Next, one will be seen, my lord.
Yes,
Well, it is only, my lord, we can, my lord, your losses may, because your losses must see the reply at page, my lord, 28 to 22. My lord, we have filed that photo may be seen, my lord, here.
no, we'll not see photo. We cannot determine this.
No, only.
See, first thing is
Yes,
that area of building has been, so this has been constructed subsequent to this court's earlier order. Okay, so
already constructed earlier, my lord, that only for this one court. allowed us
no,
to- yes.
now the building has been constructed more than approved plan, which is within, what is the, how can we believe this? Is it a report?
Lordship, we annex it, Lordship.
Huh?
We annex the report also, Lordship.
Where is that?
Annexer 7, page 117 is annexer 1.
Page?
Additional affidavit, subsequently filed.
Subsequent additional affidavit we also annex and
Where
earlier
this
affidavit we
additional,
also annex.
additional affidavit filed when? Additional affidavit of petition filed by Lakshmi Kharghoria.
Yes, Lordship.
Huh?
Yes, Lordship. In annexer 1, Lordship, and deviation is there and report is annexer 2. Page number 135,
134.
35. Lordship. 34 and 35. 34 is deviation is.
Now show us which, under which provision these are compoundable.
It is Lordship under Assam notified urban areas other than Guwahati.
Which are the provisions?
Compoundable is Lordship, it is in schedule 7.
Anywhere in this part of this,
This
give us, I do not think this is a, no, what I'm asking is, what are the violations? First violation is constructed more than approved plan. Okay, first point is more than approved plan. More than approved plan is length of the building has been constructed. Where is the provision which permits you that construction beyond the length is compoundable?
compoundable is also stated in that schedule.
That
Lordship.
says that if a building or part of the building has been constructed unauthorizedly without obtaining required building permission authority as required, the same shall be compounded at the following rates. So
Yes,
it is a case where a building is constructed without permission.
Lordship, unauthorized
And part
construction-
thereof, suppose you give up, if you give up, according to this codes, so far my knowledge goes, the setback is not at all compoundable.
Lordship, unauthorized construction is in the provision is there, Lordship. What is unauthorized construction? In that beyond permission, Lordship.
No, that we understand. There are some specific provisions. We'll have to go through it. Where there are specific which are compoundable and which are not compoundable. The provision you are relying on is in respect to a construction unauthorizedly without permission. That is without obtaining NOC. Say somebody constructs a house without objection. Then you can regularize it if it is within the prescription of setback so and so, so and so. In the building bylaw or under this notified areas, there are certain provisions which says that you cannot add a floor. Okay. Setback cannot be compounded. Descent and so on and so forth. However, there is a provisions, the rate of these, and there are some other categories where it is compoundable to an extent. And what you are relying on is the fees of compound.
Lordship.
We are not on that. What we are asking is, where is your power to compound
the thing.
additional exceeding additional construction violating setbacks and height of the building. Where is your power? We want to know that. So see, this book is available somewhere. There is a book notified building bylaws, town and country planning and building bylaws. Yes, what you say? What are these provisions? Have you gone through it?
No, not.
If not gone through it, we will not waste time.
Not even any other.
We will not waste time.
I only make one thing, madam. There is an order passed by this honorable court in IA number 1780
What it says?
My lord, the order was very specific, my lord. This honorable court has directed the petitioner to carry out the construction strictly as per the approved.
No, that we understand. As per approved plan. So according to the, therefore report was called for, whether construction is done or not. The authority says you have inspected, these are the construction done subsequent to this date, cut-off date, not the earlier provision. This date, and these are the violations, these are compoundable. We want to know which are the provision authorities, because they are silent under what provision this can be done. If you are ready with that, we are proceeding. If you are not, then we are adjourning this. We must come to a conclusion, isn't it? That is required. You also go through it, because there are something, some provisions that these are compoundable, these are not compoundable. What she is relying on is the rate of compound. I want to know where is the power which says setback is compoundable.
That's it.
On the prayer of the learned counsel for the parties, matter stands adjourned and be listed after puja vacation.
It may be.
No. If you are not, we have fixed this matter on a Thursday with an expectation that we will finish it up. After 10 minutes, we will be out of job.
May I please? Here, my affidavit in file.
Hmm.
I've gone through the affidavit in the meter. It was served, my lord. The one page was missing. Later on, I took a certificate copy, my lord. I will file a short reply, my lord. This is read in the acquisition. And that's redone on 2009, but the award was passed in the 2015.
Though an affidavit has been filed by the state respondent containing that the land acquisition, subject land acquisition processing was carried out in terms of the Act 1894. Comma, the case of the petitioner is that they are entitled for compensation in terms of 2013 Act, more particularly on the ground that the entire processes were initiated in the year 2015.
Award is passed on 2015.
Award was passed in 2015, and therefore they are entitled for the benefit under section 24 of the Act 2013. Full stop. In the aforesaid backdrop, the fundamental issue in this writ petition is whether the land acquisition, whether the petitioners can be granted compensation in terms of the provision of Act 1894, or they are entitled for better compensation under section 2000, under the provision of Act 2013. Full stop. The principle in this regard has already been settled by the Honorable Apex Court in Indoor Development Authority versus so and so, so and so. Therefore, to come into a conclusion, certain vital aspect of the matter should be brought on record by the state respondents. More particularly, the date and copy of the notifications purportedly issued under section 6 and section 4 of the Act 1894, full stop, comma, the award that has been passed, purportedly passed in the land acquisition process in question, and any approval that has been sought or granted by the competent authority in terms of section 11 of the Act 1894. On the next date fix, the aforesaid materials be produced before this court either by way of an instruction or by way of an affidavit. Full stop. In the meantime, the petitioner is permitted to file a reply affidavit to the affidavit in opposition filed by the state. This is the issue. So many, nothing is required. We need, what was the date of section 4, section 6, again, and the date of taking over possession of the land. Possession and the award. That will determine, law is well settled, formula is given. After first week of November.
May it please your lordship.
Mm.
I'm appearing on behalf of B. Gogoi, my lord.
Mm.
My lord, with regards to item number 9, my lord.
Mm.
We have received our instructions, my lord.
Mm.
And this item fall under the jurisdiction of central government, my lord, CGST, my lord.
Mm.
Not state GST, my lord. We have our instructions, my lord, as the notices were issued by the central GST, my lord. And with regards to item number 10, my lord.
Mm.
2 days may be given. Our instructions are still awaited, my lord. 2020 meter, my lord.
But this is a non-registration.
Yes, sir, lord.
Is there a reconciliation of registration?
1 minute, my lord.
On the prayer of the learned council, you file an affidavit, then only they can respond.
Yes, sir.
On the prayer of the learned standing council for taxation,
And taxation.
finance and taxation matters stands adjourned and be listed on. Give a date.
After 1 week, my lord. After 1 week.
After 1 week, give a date as per your convenience.
20.
20. Interim order pass earlier shall continue. Till then.
My lord, 11 also we have received our instruction, my lord. It's a detailed instruction, my lord.
Learned council, same order.
Same order.
Time. Then it will go after vacation.
My lord.
11 will go after vacation.
There is an
Interim order pass earlier shall continue. Till then, give a date. After vacation, give a date.
22nd.
22nd.
Only obligation.
File a fresh application.
Lordship,
File a fresh application giving details.
Lordship, here in this,
Unnecessary, you are
Yes, Lord.
fighting here. They have taken a stand, these are the materials we want, as per online you file it, they will do it.
Lordship, my understanding, Lordship, if they required some documents in online portal, Lordship, it's automatically reverted back. But here in this case, Lordship, they did not revert it back. As because, Lordship, all the documents I have in the petitions, Lordship, I have annexed. And whatever the documents is required, it is also mentioned in the online.
Now, what
portal.
kind of order can we pass? Tell us.
Lordship, my submission is that, Lordship, all the documents I have submitted,
So we'll issue a direction to issue NOC.
Lordship.
Huh?
Lordship, as because Lordship kindly peruse. One thing, Lordship,
This is remain, that is what remain. Now that revenue authority had made us the appellate authority against the order of circle officer, against the order of settlement officer. We have become that already.
Lordship,
Because they will not do anything. And when a writ petition is filed, they will give all the details in the affidavit which they can give to the petitioner. Here they have taken a stand that these are there. Now, how will decide this is not there or this? Please
Lordship,
tell us, please assist us.
Lordship, I at first, Lordship, if we see what are the documents required in their portal, I have that
Do
Copy
you have the
annexed,
downloaded? Huh?
already annexed, Lordship.
Where is that?
Lordship, kindly, my first page 14 is a Jamabandi, it is a land documents, Lordship.
Hmm.
Then, Lordship, page 19 is important.
Well, who is the authority who can grant you the permission?
Lordship, Deputy Commissioner, Lordship.
Where is the deputy commissioner's affidavit?
Lordship, their affidavit is, Lordship, before going to affidavit, Lordship, kindly page 19. What the documents is required in online portal is mentions, Lordship, that documents. And as per requirement,
So therefore, let us see first what, according to them, what they have not received. Then we'll go to the portal,
yes, sir.
whether that is necessary. This is your case. Yes, sir, let us see. Unnecessary, you are fighting here since 2023.
Lord-
You could have corrected, you have gotten this report.
Lordship,
There is an appellate of authority.
Lordship, in this petition, I already stated, Lordship, in this column, appellate provision is there, but Kamrup Metro is not there. But in their affidavit, it is admitted that at that time it is not there. That's why, Lordship, I was helpless, Lordship.
Okay, show us. Show us the,
Lordship, they are kindly in my additional affidavit, Lordship, their rejections order is annexed, Lordship. After filing of these writ petitions, they rejected.
where is that?
Lordship, in my additional affidavit, Lordship, kindly peruse, Lordship.
Space, tell us, space. So many affidavits.
Lordship,
Where necessary, they will not file affidavit.
Lordship,
Where unnecessary, they will file 10 affidavits. Yes,
47, Lordship.
it is the interest of the circle officer.
Yes, Lord. Circle officer and lot more. That's why I'm making in by name party. And
That we understand.
Lordship, why this they rejected, Lordship? As because, Lordship, as per Right to Public Service Act, they have to make a payment for delay, Lordship. So that's why, Lordship, I have already prayer is there that compensation as per the Right to Public Service Act. So that's why, Lordship, they rejected. After receiving of this notice of this Honorable High Court's order, Lordship, notice, they rejected. Kindly peruse page 47. Why they are rejected, Lordship?
Page
Lord-
47.
47, my Lordship, it is Lordship, continuous designations. 47, Lordship. Lordship, kindly peruse one thing, Lordship. I have made an application 17/12/2022. 17/12 at stipulated time period is 30 days. After receiving of this notice of this Honorable High Court, Lordship, on 9/5/2023, that more than 1 year, they Latmondol forwarded this file to the circle officer. Circle officer on the same day, it is forwarded, Lordship, and its reason is showing, Lordship, last column number 3, Lordship. The application is rejected by the ADC, rejected as per recommendations of CO, applied that not have the area of this land applied. Lordship, here in this regard, Lordship, I already category mentions we can't import any nahi more that number or any patta number. As because, Lordship, in portal, when it is input the details of the seller, it comes to the location of the land. Sub-district, circle officer's name. Ultimately, Lordship, it come to details of the land. When it put as a patta number, it automatically come into
Okay,
that
now
number.
according to you, there is already land.
Yes, because, Lordship, all the documents, land documents, I also annexed here. So, Lordship, they whimsically saying, as because, Lordship, they rejected because of, Lordship, that I have made a prayer that as per the Right to Public Service Act, after 30 days, they have to make a payment. So that's why, Lordship, so for my understanding, Lordship.
Show us the act.
Lordship, Lordship, before going to the registration in the Registration Act, Lordship, it is section 21.
No,
Okay.
I want to know the timeline in terms of the
Yes,
act.
Lord. Yes. And
And
timeline,
if it is not done in timeline, what is the amount to be paid?
yes, Lord, per day to 250 rupees. And if you one more thing, Lordship, if intentionally or malafidely rejected if any application, then also, Lordship, they have to pay. So I am not going that part more, Lordship. I am
So according to you, what is the period
30
See.
days, Lordship,
from?
from date of receipt
Hmm.
when I made this application.
So you, where is that provision section?
Lordship, 21, I have all marked, Lordship, in
Section 21.
21 and second part, Lordship. decision.
Where is your speaking order?
Lordship, speaking order there, after filing of this petition.
Where is that speaking?
Lordship, that is a page 47, whatever I already read, Lordship. That is the speaking order. As per their versions, Lordship.
This is the speaking
This
order.
is as per their versions. And moreover, Lordship, kindly peruse page number 39. Here in my petitions, Lordship. There also time bound is given, Lordship. 10 days for Nath Mandal.
So it is a provision that it should be issued within 30 days.
That, Lordship,
So when have you filed the application?
Lordship 17/12/2022.
Where do we get that?
Lordship, page 40, Lordship. Sorry.
লিখে যাবো sir. Application was filed on
Lordship. File on 17, Lordship, kindly came on page 20, Lordship. Here, this is the receipt copy, Lordship. Here it is details mentions, Lordship.
$530
Lordship, page 20, Lordship.
page.
20. Date of application 17/12/2013.
Just a minute. Page 20, page 20.
20, Lordship.
Yes.
Yeah, Lordship, it is also it is
Just a
mentioned,
minute.
Lordship, 30 days provided within 30 days.
Page 20,
20.
7/12/2022.
In the
Okay.
in the body of this petition page, Lordship, is stated provided within 30 days.
Where is that?
Lordship, this first your application for NOC for same class so successful on 17/12/2020 and your acknowledgement number is so. Please use this acknowledgement number for the taking in the applications and for any future communications relating to these applications. If the application has been accepted by the Land and Revenue Department, and the service shall be provided within 30 days.
Hmm.
You may raise an appeal so if the service is not delivered within 30 days.
Hmm.
So, Lordship.
Now tell us. Okay. So you have filed on 17/12/2022.
22.
And when this speaking order was passed?
Lordship, is it passed, Lordship, 7 on Lordship.
Page
12
page 46, is that it?
47.
Huh?
47, Lordship. 12/5/2023. That after receiving of this notice of this Honorable High Court.
12, where is that order, speaking order?
Lordship, last column number 3, Lordship.
Notice was issued when?
Lordship, notice was issued, Lordship, 26/4/2023, Lordship.
26
4
4
2023.
23. Okay. Now tell us, what is the period prescribed for each stages? Malat Mandal,
Yes,
Circle
Lordship,
Officer.
Lordship, that is kindly coming to page 39. 39, my petitions, Lordship. Lordship, is the first Lordship is the issuance of an no objection certificate for transfer of immovable property.
No, what is this? This is, what is this? This is issued under?
Lordship, this is issued the Lordship as per the Right to Public Service Act.
Give a copy of the Right to Public Service Act. Why not? This is the bench. You have made these two parties?
Yes, Lordship. Yes.
This,
My name, I have marked.
notices served upon them?
Not this up, but they did not.
Okay. Okay. Which provision? Tell us.
Lordship, section 4, Lordship, kindly peruse.
Section 4.
Lordship, in this act, it is stated, Lordship, time to time, they are notified this service. So accordingly, Lordship, this service has been notified. Page 39, that is the, as per the law, Lordship, these notifications or this guideline has been given, Lordship. That
Okay. Okay, section
4, Lordship.
4.
Lordship, section,
Section 4 and this in terms of that notification.
yes, Lordship.
ARTS service index.
Yes, Lordship. Then 30 days, Lordship. Stipulated time period is here. It also mentioned 30 days. 10 days for circle officer, 10 days for Lat Mandal, 10 days for DC office.
Suppose they cannot do it, what will they do?
Lordship, then ultimately they having appellate options. But in this case, Lordship, then in this
There is
appellate-
no appellate.
no appellate. So that's why I have not
Now,
imposed.
what is the power of the appellate authority?
Lordship, first appellate authority, the DC, Lordship.
No,
Then Lordship, second appellate commissioner.
Hmm.
But Lordship,
no,
nothing.
no, what is the jurisdiction? What will they do?
Lordship, kindly that act, Lordship, 2012 act,
Which
Lordship.
section?
Lordship, kindly come into Lordship, section 8,
Section 8.
Lordship. And penalty part, Lordship,
Where is the appellate provision?
Lordship, Lordship, page, no, so, section 8, Lordship,
Section 8, 8B,
8.1, Lordship, that is
8A.
8.
8, appeal.
Appeal, second appeal, Lordship, that is there. And penalty part is there, Lordship, section 9.
Is there any appellate authority for Kamrup as on date?
Lordship, as per their affidavit,
No.
Lordship. Now, Lordship, they are saying, Lordship, it is under process.
There is a notification in the year 2022. I have sent it to him also by WhatsApp. The period of 30 days has been extended to 45 days.
45 days.
45.
Then 45 days is over when? In this case?
45 days from the date of application.
Now, in this case, was it within 45 days rejection?
No.
It is 1 year.
1 year, 6 months.
1 year, 6 months, admittedly. Now, two issues here. One is as regards non-disposal within 45 days. Let us admit it to be 45 days. And second issue is the reason of rejection. Reason of rejection is to be dealt by an appellate authority. Appellate authority is not there. Now, who will decide?
What I have understood from page 47,
Mm.
it is a reflection about what is reflected in the online portal.
Mm.
But in the affidavit, the stand is taken by DC.
No.
Oh.
Where is your speaking order? Then only we will know.
Speaking order cannot be uploaded in the
So show us the speaking order.
they have to bring on record.
Show us that. You cannot by affidavit explain your reason. That is law is well
Yes,
settled.
yes. That is
Gill,
fine.
MS Gill, or what was the Gill? That is gone. That is done. You cannot. Your in one liner, it is that land is not. There is no land.
Then is
On-
not telling with the record.
Not telling means there is lesser land.
Lesser land.
Lesser land. Not telling is not the case.
Yes, yes.
Land is lesser land.
Lesser land.
So this is your ground.
Secondly,
Uh.
as per the affidavit, madam, two DUG numbers cannot be applied in one application.
Where is the speaking order? That is not the reason given
Yes.
to him. You cannot improve your case by filing affidavit.
That they have to bring on record. The ADC has
You have not brought on record. Well, why should we give you time?
Lordship, already affidavit filed, Lordship, that's why.
You have filed affidavit. Matter ends there. Is
But
there
the-
any mandate that and every time we'll give you a chance to rectify your defects?
since the matter has cropped up.
No, matter will crop up. It is not a case that you will become wise when court puts question,
Correct.
isn't it?
Yes.
Or you want to be wise? Oh, I forgotten this. I will give an additional affidavit. Then another question will come on the next date. Oh, I will do it. This is not the way government should deal it. So we will not give you any chance to file any affidavit.
Last chance, as a last chance, Judge.
No last chance. What last chance? We are in a Thursday morning at 11 hearing a matter. How much cost will you pay? Tell us. We'll give you a chance. How much? How much to be paid to him?
Have to,
What at to? No at.
Lordship, my submissions, Lordship.
Yes, proceed.
Lordship, if possible, Lordship.
Hmm.
Lordship, as because Lordship, whatever Lordship, I need.
See, we are disturbed to see the application, the legislature enact is a legislation.
An
Act
act.
of legislature. Let us remind you what is the object of the legislature. It is expedient to provide for delivery of notified public services to the people of state of Assam within the stipulated time limit and for matter concerned therewith or incidental thereto. And these bureaucrats are defeating the object of this legislature for their whims and fancies. Isn't it? You will give one reason, you will file an affidavit. Therefore, that's why I have, on the very beginning, I have said, when there will be necessity to file affidavit where contentious issues are there, there is no affidavit. And in this case, everybody has filed affidavit. Why? Yes, proceed.
My submission is that, Lordship. Lordship, if possible, Lordship, a directions may be given to the DC Lordship, and he may be issued a as because.
No, we cannot see. We know our, we cannot say that you are entitled for an NOC.
Yes.
We are not sitting as an appellate authority, not as a deputy commissioner. Our job is to see whether procedure prescribed under law is followed or not followed. If followed, very well, we'll dismiss your petition. If not followed, we'll pass the necessary order. We cannot sit as an appellate authority as regards whether this land is this or this land is that. That I made it very clear. We are not here as a appellate authority. We are not here to decide who is entitled for NOC or who is not. We are here to see whether they have any duty, statutory duty, whether they have performed it, and if not, whether non-performance has violated your right. If that, will pass the consequential order. That's all.
Lordship, in this regard, Lordship, just I would like to one line,
Ah.
Lordship added, Lordship. Lordship, they are saying that the land is not there, that number is not there. Lordship, in my additional
So
affidavit.
therefore, now the next question is, forget about the procedure. You don't have any appellate authority. Who will decide? Your person cannot be remediless. This is one. Suppose we say that this is a, what is the second appellate provision?
Lordship, second appellate.
Second appellate provision is given only to the,
First appellate authority.
no, only to the beneficiary or to the state also.
No, Lordship. Here, Lordship, only beneficiary. When it's rejected, refused, whatever delay, if delay, then Lordship, he filed to first appeal. Then after 30 days, then he can file a second appeal.
So there is no right of the state to prefer appeal.
Yes, Lordship.
There is no right. Therefore, why I am putting this question is, suppose a person cannot be remediless. So in that situation, when appellate authority is not notified, then of course writ court will have a power to decide. No doubt about it. But if state is, suppose we decide in your favor, state is having a right against, to file an appeal against that order, then against High Court's order, there cannot be an appeal by the appellate authority, second appellate authority. That's why I'm asking this question, whether right of appeal is given only to the beneficiary or to the state.
Beneficiary.
Let us see this provision. If state is having a right to prefer an appeal, then of course we cannot decide. Then we'll have to relegate. Otherwise, if there is admittedly no appellate authority, we can.
Lordship, kindly peruse section 8, subsection 1, Lordship. Any person who does not get notified service
Hmm.
within the stipulated time limit it specified under sections 4 or in 4
Okay,
is any person or Lordship who does not get notified service, Lordship.
now where is the second appellate? Second appeal?
Second appeal, Lordship, here, Lordship,
Second
subsection 3. No, Lordship, subsection 4,
Subsection 4 of section
8. The applicant aggrieved by any order of the appellant authority may make a second appeal within 60 days from the date of receipt of this order of this appellate authority in the appeal before the commission.
Where is the statement that appellate authority is not there? Where is the statement?
Lordship, paragraph number 12, Lordship.
Paragraph
12, Lordship.
12 of whose affidavit?
Page number 8, Lordship.
Page
Page 8.
8 of?
My petition, the writ petition.
No, that it is your statement. What is what is their stand?
Lordship,
That there is no appellate authority. Under process, you have said just now that
Yes,
they are
sir.
saying that under process.
yes. Lordship, page 40, Lordship, affidavit, Lordship, kindly
Yes.
come into page 49.
Page 49.
Yes. Lordship, 50 is the relevant page, Lordship, paragraph number 8.
Hmm.
With that, with regard to the amendment made in paragraph number 12 of the writ petition, the deponent beg to state that locations such as DCOPs, circle office, subdivisions of all the districts are available in the online, so and so. However, against a few service, all the locations are not showing as the official mapping is under process, Lordship.
However, currently Kamrup Metro is available for the particular service under the
At that time, it is not available, Lordship.
okay. Okay. Yes.
Lordship, what I propose, Lordship, let me have the records, Lordship, of that case, whether why it has said that no land is there, then it will be clear, Lordship, because from affidavit also, Lordship, we cannot find anything. So
Heard
let me have
the
that.
learned counsel for the petitioner at length. At this stage, Mr. S.S. Roy. The heard Mr. Learned counsel for the petitioner at length. The perusal of the material available on record, including the affidavit filed by the respondents, goes to show that the application of the petitioner filed under Assam Right to Public Service Act 2012 was not closed within the prescribed period of time. 20 minutes. And we take weeks to deliver the judgment.
Records are also very
Isn't it?
voluminous.
No, record is nothing here. It's
Entire proceedings.
fundamentally what is the perversity and how we can issue the writ of certiorari.
This is all.
This is only part. We have already in some other judgments laid down the proposition under what circumstances we can interfere with an order. That's all. When?
Your lordship
No, I had a convenience today to have fixed it.
I am also.
And he had also not intimated yesterday.
No, I apologize for this. If lordship is finding it this inconvenient.
Generally, we feel difficult. This is not fair on upon the court. Anyway, what to do? This is the practice. Anyway, when give a date?
No, it is up to him, what will be his convenient date.
After it will go after vacation. She also did some homework. Read
Yes,
the
that is the
files.
problem.
Anyway,
also made my
this
homework.
part of our
He
profession.
could
Lawyers
inform us, he has
lawyers
read
are time and again not cooperating, even after there are notifications that it should be intimated prior.
Lordship may take
But
up
we
the-
will have to look into the face of the client. We
Okay.
can dismiss it. We can, without hearing, we can proceed it. But we do not do that. Anyway,
Lordship may continue with the
give a
matter.
date, give a date.
Difficult.
Let us not
When
waste time.
it's some problem, all right. But my respected prayer before your lordship will, if possible, it may be fixed within this week or after this week. If possible, of course.
Okay, we'll give a chance before vacation. Yes. Give a date before vacation. Muslim. 3rd of October. Let us see.
Deeply obliged, Lord.
But if you are not there, we'll proceed.
Definitely, Lord.
Yes.
My prayer was only tomorrow I would have done my part. Only that.
Your
only that.
convenience will not. We have
I
already
understand.
fixed methods
I
for this
understand,
to
I
come.
understand.
That cannot be.
I just
that-
faced my predicament. That's it, Lordship.
Yes, next
So whether to take the matter, I can still be here and
Next,
contribute the hearing.
next case.
Obliged.
Yes.
May it please the Lordship.
Hmm.
My Lord, earlier, my lord, the petitioner approved this on court, my lord.
Hmm.
And there's a judgment, my lord, page 37. And relevant portion, my lord,
Page
37, my lord. That from page 36, relevant portion, my lord, page 46.
Where is that order dated 5/6/2002?
Page 34, my lord.
Page
34, annexure 7.
What is there now? Now, what is your grievance?
Now, my lord, we have not been given any settlement to any.
You are still in that
Yes, my
area.
lord, Lordship.
What is the stand of the government?
They filed, my lord, affidavit, my lord,
Ah.
saying that we are occupying land since 1980. And
Now,
there
what is their stand?
There is no alternate land for our
This is the. And
Are
during
they,
pendency, my lord,
uh,
we have applied, my lord, under Bosundara scheme.
uh,
Because of pendency of this case, our application has also not been considered. We filed affidavit, my lord, on.
yes, right, complicated situation.
Lordship, on.
We
Our
have received an instruction
application,
on 2022 that there is no other alternate lands and they have not made any application for alternate prayer roads.
There is no application is required.
Required lordship, but,
The judgment is clear.
but there is
It is
no
up to you because see, two documents are there.
lordship,
Admittedly, they are occupying a grazing.
lordship.
Grazing part cannot be denotified. Of course, there are some provision. It can be done if alternative grazing
Is there.
equivalent grazing field is created. Now, they applied for settlement. Admittedly, they applied for settlement.
Lordship.
You recommended also.
yes, my lord, dear.
Recommended, but that recommended was withdrawn
Withdrawn,
on the basis of some public
Public
complaints that
complaints.
this land should not be given.
lordship.
However, the recommendation is modified, recommending
Deed
that should not be
Sorry.
reserved, recommending that settle them in some other places. So a decision has already been taken
Taken.
by the government to settle in their favor.
Right.
Second part is, they come before this court. Court says we cannot interfere with this decision. However, they should be settled in another place. So there are two parts. One is the policy decision of the government to settle them. And second is a mandamus is already there where says settle them.
Settle them,
Until such settlement,
status.
they should not be status quo. So they are still occupying the grazing reserve. So the purpose of keeping the grazing field is also not there.
Not there.
And you are also not settling them. So you'll have to have a concrete, you cannot blame them that they have not applied. That instruction will have nothing. You have the present status,
Lordship. It is the last status of 2022. It was.
what
the-
it says.
It says, lordship, there is, so no alternative land is found.
So then what is, how will you do the, how you deal with the High Court's order?
Lordship, that is there.
That order has not been challenged also, that remains there.
Present status, let me have some
Okay,
instruction.
Mr. No, the petitioners who claims to be indigenous landless people. Indigenous landless people approaches this court seeking settlement in terms of indigenous landless flood affected people. Seeking settlement in terms of the judgment, in terms of an order dated 5/6/2002, whereby the additional deputy commissioner ordered its to passed in de-reservation case number 3 of 2000 passed by the additional deputy commissioner. By the aforesaid order, though initially it was proposed to de-reserve a grazing ground, de-reserve what?
Plot.
It was not mentioned that grazing.
de-reserve certain lands, de-reserve certain lands to settle the petitioner. However, due to objection of certain institutions and renowned personality of the, however, in view of certain public complaint, such proposal of de-reservation was dropped, and it was provided that the petitioners shall be settled in alternative land. Being aggrieved, the petitioner preferred WPC 4354/2002, and this court, under its judgment and order dated 18/6/2019, while declining to interfere with the order dated 5/6/2002, directed the state government to make alternative arrangement so that the petitioner can be settled in any other government land as indicated by the additional deputy commissioner in its order dated 5/6/2002. And till such alternative arrangement is made, it was further provided to maintain status quo in respect of possession of the petitioners. It is the contention of the petitioner that the petitioner are still settled and occupying the aforesaid land, and no alternative arrangement has been made till date. It is also contended by Mr. Ali, learned counsel for the petitioner, that during pendency of this proceeding, though they had applied for settlement under Mission Bosundhara, however, due to pendency of this writ petition, their applications were not accepted. First up, at this stage, Mr. Roy, learned counsel, SS Roy, learned counsel, submits that he would like to obtain the present status of settlement of land in favor of the petitioner, in as much as there is a mandamus for settlement of the land. Accordingly, he prays for an adjournment. Prayer is allowed. Place this matter on
Lordship, after vacation.
Give it.
Some review petition is also filed. I am just now saying,
Okay, okay. You have it.
after the vacation.
In the first week of November. Give a date.
Lordship.
5th of November.
Pendency shall not bar to consider.
Pendency shall not be barred for the authorities to consider the case of the petitioner for settlement in a settlement in terms of any policy of the government, policy and procedure of the government, considering the mandamus issued by this court as recorded here in above. 20 Matiga.
I think 20.
I think it has got to be infractuous one because
18 and 19 said infractuous.
Yes.
So what about 20?
20 is appearing. Don't appear second. 20.
uh,
20 to more saying.
Item 18 and 19, a submission was made that this has become infractuous.
22 man. Sorry.
None appears for the petitioner on call. Though Mr. Talukdar, learned standing counsel for cooperation department, submits that the matter has become infractuous. Full stop. Considering non-appearance of the petitioner, matter stands dismissed for non-prosecution. Interim order, if any, stands vacated.
One.
None appears for the petitioner on call. Yes. You are for?
Handloom textile.
Huh?
Handloom textile for on behalf of Mr. Arthur.
On behalf of Mr. R.
Aadhar,
Aadhar for which department?
handloom and textile.
Handloom and textile. Is he present in the court?
But he's on legs now.
Huh?
He's
He's on
on
legs. None appears for the petitioner on call. Though Mr. Aadhar, learned standing counsel for handloom and textile is present. It is the case of the petitioner that pursuant to an NIT issued by respondent number 2, inviting tender to run the Weavers Guest House in the 5th floor of Directorate of Handloom and Textile, Assam. The petitioner was awarded the contract to run the said guest house initially for a period of 3 years with effect from handing over of the guest house with a provision for extension of another 2 years or another 2 to 3 years at monthly rent of 15,330. However, by an impugn order dated 29/7/2017, the respondent number 2 however, by an order dated 21/6/2017, the respondent number 2 closed the guest house run by the petitioner with immediate effect. By an order dated 22/6/2007. Full stop. Such decision was the petitioner was also asked to vacate the guest house. And thereafter, the petitioner preferred a representation on 23/6/2017 before the respondent number 2, praying for reconsideration of the matter and to allow him to run the guest house for a period of 3 years as per deed of agreement, which was not considered by the respondent department, and being aggrieved, the petitioner preferred the writ petition being WPC 3995/2007, which was disposed of by this court under its order dated 30/6/2017, with a direction to the respondent to consider the representation of dated 23/6/2017 and pass appropriate order thereon with 4 weeks from the date of passing of the order. Full stop. Subsequently, such representation was rejected by an order dated 29/7/2017, which is under challenge in the present writ petition. That he is not here, he is out.
He is out, my lord, matters become infructuous. Therefore,
That's why. Full stop. Full stop. Full stop. It is submitted by Mr. Dhar that subsequently, in the meantime, what is the status of the guest house?
guest house, my lord, is it has been converted to office, my lord.
Okay, full stop. Submits that the guest house, referring to the affidavit file, Mr. Dhar submits that the guest house was permitted unauthorizedly, and subsequently a policy decision was taken to convert the guest house into office of the department, and accordingly there is no guest house is existent as on date.
He challenged thereafter, my lord, that decision, that also dismissed.
Okay, full stop. It is submitted by Mr. Dhar that such decision to discontinue the guest house was also challenged by the petitioner in WPC
WPC number 2684 of 2020.
2020. Just give a order.
Mal-
Which was also dismissed by this court under its order dated uh, order dated
5820.
5/8/2024 for non-prosecution. Full stop. When this as none appears in the present case, the present petition stands also dismissed for non-prosecution. What is the WPC 4782? This is, oh, no, okay. What is I? I also dispose of. In view of the order passed so and so, I stands closed.
Well, in item 22, this
Hmm.
has been dealt by Mr. R. Borbuzari.
Okay,
He has some difficulty today,
okay.
some other day.
My lord, every time I prepare and other sometimes.
That we have already already have expressed our.
All my hard work gone in vain, my lord, goes in vain. Because my lord.
Take it
Can I-
for granted that you'll have to do hard work every day, whether it goes waste to the drain or it gives any reason.
Sometimes again they are taking time.
On the, it is submitted.
2019
The
matter.
petitioner is still alive. The original petitioner is around 72 years.
Yes,
Again.
yes.
On the prayer of,
Yes, answer.
it is submitted that Mr. R. Borpuzari. See, generally, Mr. Borpuzari, at least this court's experience that he remains present. But today, it is an adjournment is sought for on the ground that Mr. R. Borpuzari, learned standing counsel for revenue department, is having some personal difficulty today. Prayer is allowed. Accordingly,
Until-
list this matter.
Till next Thursday.
No, not before vacation. Hearing is not possible. We'll stop hearing from next week.
It's coming again. Again
After
in
vacation, with fresh mind after enjoying puja.
November month.
From Monday, hearing will be
Okay.
difficult.
So,
Of course,
if-
very urgent, all matters there will not avoid, but
If we don't
this
find
is-
person, we need not come then.
no, you need to come. We are taking admissions, final hearing matters, which will take time, because this matter will take time. Many issues are involved, whether they can pass this awards, Zamindari Act, the compensation, many things. We cannot dispose it of like
It will be in November, madam.
November,
But
5th of November.
5th of December.
6th of November. Okay, fine. Oblige.
Yes.
Alright, fine. Just leave it.
List is
Last
over.
time,
no?
but-
Yes,
My prayer is also for adjournment.
these are called ventilation. Nothing more. These are called ventilation. This is a part of record.
Part of record. though.
This is a part of it.
2010.
2010. It
part
was
of
in
record.
2015.
No,
What is your problem with this? Tell us.
Lordship, kindly take up the matter.
Then before that, Lordship may also go through one judgment, Lordship, on this particular notification. But paragraph 23 and paragraph 42.
Paragraph.
23 and 42.
Paragraph 23 and
42.
42.
42 is the finding of the court.
Ventilation. Nothing more.
Lordship,
And if
my
there is
petition-
some other question of other instruction, we do not know, but it's ventilation. Page 40,
Paragraph 42.
40.
Page 15.
What more you require? See, this 42 and
43.
43. Yes. This is your whole ground.
Lordship,
Only ground is that there is no authority. And authority has been answered by coordinate bench. We,
the other part will also there.
other part will not go. Whether you have, whether it was for you, damage has been created, or for them, you could not complete. These are the subject matter of arbitration or civil suit. This is not our
Lordship,
subject.
Yes, there is a contract agreement, Lordship, but they are bound to follow the provision, Lordship, of the agreement. So this is my whole case, Lordship.
Your whole case is that there was no fault on your part. There was flood, this, that, and there was no fault. It is for them why you could not, admittedly, you could not complete within time.
Lordship.
So your whole case is that it is not for you, but for them, you could not complete. This is your first ground. That ground cannot be decided in writ petition since it involves factual determination. It is whose fault?
So so-called notice was not issued, Lordship. The one part, Lordship, the other part I have no given.
So cause notice is there issued, you filed a reply also. You have filed reply also.
And the second part, main contention, Lordship.
Main, so
jurisdiction,
therefore,
sir.
so cause notice issued, you file reply also. But they have, issued the termination. So therefore, your second ground of termination is that such authority under the contract is having no authority under law to terminate the
Terminate,
contract.
Lordship.
And according to us, such ground can be decided by a writ court, even if it is a contract. That is clearly held in that is Bhopal authority. What was the case? I forgotten. That will deal with. So that clearly says then when it is an order of termination is issued without authority of law, then a writ is maintainable. So there is your ground, therefore we are examining. Now while examining, it comes to our knowledge by virtue of a judgment that the notification which according to them is the authority, according to you, which is not part of the contract, has been dealt with by a coordinate bench, and coordinate bench says this is an authority. So matter ends there.
No,
It's-
Lordship, kindly, Lordship, look their letter and my reply, Lordship. Their letter, kindly, Lordship.
Yes,
for a
where
moment,
is-
Lordship.
where is
for a
that?
moment, Lordship.
No, yes, where is that? We
Okay,
give
they-
patient hearing, no problem on that.
Lordship.
Where is that?
Their affidavit number in WH 395, Lordship.
3344.
395, Lord. Kindly take out the
395. Page?
Page, Lordship, 30, their affidavit in opposition,
Page
filed
30.
by 1, 2, 3, 4, and 5.
Page 30.
Annexure 3, Annexure 3, page 30.
Yes.
Lord, can we see the contention of this letter? It is general authority letter to whom it was given, that is not written here, Lordship.
That has been dealt in
No,
this judgment.
I am coming to contention, Lordship.
Yes.
The special condition of contract agreement PMJ works 5 clause 4(1) of section part 2.
Hmm.
Kindly note this line, Lordship.
Yes.
PMJ work 5 clause 4(1) section part 2, if required, it required the engineer to take specific approval. I am not coming other part, Lordship.
Yes.
Only this line, Lordship.
Yes.
Lordship, kindly come to my repetition.
Hmm.
Special condition of contract, page 89, Lordship.
Just a minute. Just a minute, huh?
Lordship.
Yes,
Well,
page,
count-
page,
Page 89 of the writ petition, Lordship.
page 89. Yes,
So this is the condition of contract, part 2, special condition of contract
yes,
of my particular contract, Lordship.
yes.
Here, Lordship, there is no clause 4.1 or 4.1, Lordship,
Hmm.
which requires given power the chief engineer to give authority to any other executive engineer or other contract, Lordship. So how this
Where is that? This is your
It is
special
89.
condition of contract. Okay, yes.
special condition of contract?
Ah.
So there is no clause 4.1
Hmm.
as held in the letter dated 25 to 2010.
Hmm.
So
Hmm.
this letter is applicable where in the contract agreement there is clause
Now,
4.1.
where is in your clause that it can only be terminated by the chief engineer?
Lordship, page 71. Not 52.
Page,
Page 71.
page 71.
Not
Plus 7, just a minute. Page 71, no?
52.1 below what, Lordship? Termination.
Just a minute, just a minute. They have wrongly given it to be special contract. It is general contract, 4.1.
4.1, part 2.
Hmm?
Engineer's decision.
Engineer's decision.
Lordship, I am.
You are at page, come to page
That
60. Come to page 60. Why this authority is required?
Lordship, page.
Page 60 of your petition.
60. Or when different, Lordship, he should take obtain approval, Lordship.
No,
Except where-
approval when? Until and unless regulation requires. Please show us which regulation prescribes permission.
Because this is a Lordship is 52.
No,
Not
no, see,
52.
let us go one by one. We have time, don't worry about that. Don't be hurry. Come to page 60. Admittedly, this is a GCC, General Condition of Contract. Now in GCC clause 4, it says engineer's decision.
Lordship.
Have you read it?
Right.
It says, except where otherwise specifically stated,
Right.
engineer will decide the contractual matter between the employer and contractor in the role of the employer. So, the engineer cannot do uh, when there is specifically provided that this you cannot do. This is one. Second, in a condition, however, if the engineer is required under rules and regulations and orders of employer to obtain approval of some other authorities for specific action, he will obtain such approval. So therefore, you will have to show two things. First thing is that for termination, it is specifically provided the contractor cannot terminate. Number one. Number two, you will have to show that there is specific rule or regulation which says that you need to engineer requires to obtain approval from the contractor. Where is that?
Let's say, 52, let's say, provide the employer may terminate the contract.
Huh?
So employer is the lordship chief engineer. And contract was also executed with the chief engineer.
Hmm.
There was no role of the.
So therefore, kindly come to clause 4.
Lordship.
What it says, the engineer will decide contractual matters between the employer and contractor in the role representing the employer, already authorized to do it under general contractor contract. Now tell us, when there is GCC and special condition of contract, which will prevail?
But this was specifically not specified about the termination of contract. Because lordship, termination is a major part that which made consequences like lordship, forfeiture of lordship security money, performance security, etc. Lordship. So this is the major part of the contract. Which might
Now tell
however,
us
that may be wrong,
where
lordship.
the termination is dealt.
Lordship.
Under the either GCC or SCC, termination will date in will provision.
Their contention is that there is a
No,
only
no,
document.
forget about their contention. Now kindly tell us, in terms of the contract, either general or special, who is the power authority empowered to terminate?
As the contract of chief engineer, lordship.
Where is that? Where is that? Clause
Clause lordship, 52, page 71.
page 71.
71.
Okay,
With contract data lordship.
page 71. Yes.
52.1, the employer may terminate the contract. Here is not the meaning, that's mentioned about engineer.
Hmm.
So kindly come to lordship, page.
If we harmoniously read these two conditions, 552.1 and 4 of the GCC, then okay, you proceed.
Lordship, page 79, lordship.
Page 79.
79. The definition, the employer, number one, the employer.
What is this contract data or to general condition of contract?
Contract.
This is special engineer. Where is the definition?
Number one, the employer
Hmm.
is Public Works Road Department, Assam, acting through chief engineer.
Hmm.
Number two is the engineer.
Hmm.
So head of respective project implemented unit of the district where the contract package situated. So he has some lordship, as per definition, lordship, he has some limited lordship, execution lordship orders maybe he passed,
Hmm.
but not the entire, as because my contract is executed with a chief engineer lordship.
Hmm.
So there must be some rule of the employer lordship. So termination is a lordship major part, which Supreme Court also said that makes civil consequences like lordship, professor of.
Yes, yes, civil consequences. Therefore, we will entertain an application when it related
So I
to
have no-
termination.
Lordship. As because the honorable court also while issuing notice lordship, also held lordship that if there is no concurrence from the employer.
That is an interim.
interim
order.
lordship.
That is an
My submission lordship, the court also lordship took cognizance at that time also
That was a
lordship.
prima facie.
Lordship.
When interim, it is we are at a hearing at a final stage.
But they have to, without taking any leave
Hmm.
or filing any affidavit,
Hmm.
they given the contract to the private respondent, which give raises the second writ petition.
Then there is no interim order.
Nothing, lordship.
No interim order is also there.
Already, no,
So
lordship.
that at that time, when you file the writ petition, you brought to the notice of this court regard first order, but still then there is no interim order.
It's because without the filing affidavit, they on the basis of this
Understand? But
document,
there is
lordship.
no interim order in your favor.
Lordship.
Is
But
it?
second time.
So at that point of time, when you have LAs, let's see, even after your interim order, the authority has allowed the contract to somebody. You file a second writ petition, but court did not pass any interim order.
My submission, Lordship, they verbally submitted that, this letter, Lordship, 2010 letter.
So we are examining as on date.
The-
We are examining whether that authority letter can be treated as an authority letter. A coordinate bench says, yes, this is a general for all PMGY and PMGY, any PMGY, this will be applicable and this is an authority letter.
The contract is same, you know.
Contract is same,
Yes.
that is why.
So that will be some, given some time, Lordship, I mean, give some time to clear this point, Lordship. Request, Lordship. So, because, judgment has been, judgment.
When
have been
Tuesday?
taken, Lordship.
Tuesday, ventilation till Tuesday.
17th, Lordship, 17th.
Huh?
Tuesday, 7th.
Tuesday.
Lordship.
Hmm. Full stop. The fundamental issue, in the present writ petition, a challenge is made to and termination of a contract, termination order dated
17, 12, 15. Lordship.
termination order dated when
17, 12, 15. Page 126, Lordship. Read please.
we are in WPC
395, Lordship.
395.
Last and in Excel, Lordship.
395, isn't it? We are in WPC
395.
assailing an order dated 17/12/2015, terminating the contract awarded in favor of the petitioner on for construction and maintenance of rural road and CD works PMGSY, package number AS-07/83. The reason for such termination is fundamentally on the backdrop of allegation of non-completion of the work within the scheduled time of within scheduled time. Full stop. The fundamental ground of challenge of such writ petition is that the termination order has been issued by the executive engineer, whereas such termination could not, whereas such executive engineer is not authorized under the contract to terminate such contract. In the aforesaid backdrop, the respondent state has taken a stand that a general authority letter was issued by the chief engineer PWD within bracket Roads Assam by its communication dated 25/2/2010, whereby his power was delegated to the executive engineers to do certain acts, including termination of contract. Full stop. An argument has been advanced that such authority letter is having no value in the eye of law, inasmuch as such authority letter is not relatable to the general condition of contract and the special condition of contract in question. Question. However, Mr. P. Nayak, Learned Standing Counsel for the PWD Department, submits that a coordinate bench by its judgment and order dated 3/11/2022 passed in WPC 2243/2021 within bracket Mansoor Ahmed versus State of Assam and 6 others has specifically held that the aforesaid notification dated 25/2/2010 is an authority to the executive engineers, empowering the executive engineers to terminate the contract, and therefore termination of contract under PMGSY by executive engineer in terms of the general authority letter dated 25/2/2010 cannot be treated to be shall be a valid termination. At this stage, the learned counsel for the petitioner submits that he may be allowed some time to go through the aforesaid judgment and respond. To stop. Prayer is allowed. List this matter on Tuesday as part heard. 19th as part heard. On 19th. And write down, we'll close this 3349, okay? Nothing is there.
No, nothing is there.
The learned counsel for the petitioner submits that that in this petition, contract allotted in favor of the private respondent was challenged. However, there was no interim order granted, and in the meantime, project has been completed. Therefore, the petitioner may be allowed to withdraw this petition with a liberty to approach appropriate forum to seek damages and compensations if so advised. Prayer is allowed. Accordingly, read petition stands closed on withdrawal with the liberty as prayed for. In view of order passed in WPC 3344/2016, IS stands closed.
We're extremely sorry, my lord. We have missed the item 14, my lord.
What was that? Why this matter is listed in order? What order we have passed? Oh, that R.S. Chaudhury's name is not
Lord,
shown.
yes.
So we have said that let her name be reflected
My lord.
and list after vacation.
Develop.
Okay, don't say non-APS, so and so APS. We have not said non-APS, we have said that it listed. That order will do. Yes, next.